This is, yes, good evening to everybody and welcome to the class of the Advanced Private International Law. And if you happen to see the course content, and you will see the conceptual issues and basic doctrinal in private international law, like what is the private international law and what is the conflict of laws, and what is the foreign law, domicile, nationality, and residence. So we are at the domicile, nationality, and residence. So without wasting the time, let me switch over to it, and I believe that you could see my screen well. Am I right? Say yes.
Yes, Prof.
Yes, that is the answer I should have to get from you.
May you please maximize the
Repeat. Repeat.
please maximize the note.
I did not catch you. You want it should be magnified?
Yes.
Then why don't you say, sir, you enlarge it or you can magnify it? So I'm trying to magnify it, but it is going to the somewhat different way. But anyway, it is 160%. Now let us see that because I already discussed the domicile of origin and domicile of choice, and where we discussed what is the domicile of origin. So if you again repeat, which is a domicile assigned by the law to a child when he is born. So if the child is born alive, naturally whose domicile will come to the child? Anyone?
The father's domicile.
Repeat.
The father's domicile.
I appreciate. Because if it is a legitimate child, and if it is a legitimate child,
From the mother's domicile.
I appreciate. So now, every person is born with a domicile of origin. That is the obvious factor. It is a domicile received by him at his birth. Definitely, the domicile of origin for every person of a legitimate birth, there would be a domicile, is the contrary to which the terms of the birth, his father was domicile. Of course, then the question comes over there. If the father, what was the domicile at the time of the father? So that domicile comes to the child. Hence, the domicile of origin through received and birth need not to be either the country in which the infant is born. It not necessarily that the infant is born somewhere. For instance, your father and mother went to the United States of America, and if you were born over there, could you say that are you domicile of the United States of America? Yes? If you don't know, say pasa. If you know it, you give the answer.
Please repeat.
Suppose you and your father went to the United States of America for the sightseeing, and where you were born over there in the USA. Can I say that you are a domicile of that USA? Don't waste the time. If he doesn't know, you say pass on. I will give the answer.
The domicile will depend on their parents.
It depends upon the parents. Because accidentally you are born there in USA, it doesn't mean that you are the domicile of the USA. Where your parents belong, that domicile will come to the child.
Your voice went off. I don't know if it is.
Okay, Dorcas, because your voice is breaking. Okay, it doesn't matter. You mute it. Okay, let us see that hence the domicile of origin through the received at the birth. I already told you that the country in which the father belongs to by race or the allegiance or the country of the infant's nationality. In the case of the posthumous child, means the father is died here. Posthumous means the rule in English law is such child as for the domicile of its mother, because posthumous means father is no more. Suppose if it is father is no more at the time, what will happen? Mother's domicile will automatically come to the child and not the of its father, because father is no more. In India, the rule appears to be the different. Of course, here they do say a little distinction to be there, but we need not worry about that one. So, an independent person is allowed to give up his domicile of origin. Yes, I do have every right to give up my domicile of origin, that is India. Because if I want to really get the choice of domicile in Tanzania, I can do so. Nobody would stop me. But the domicile of origin prevails until the domicile has been acquired. So, unless until the acquired domicile comes into the picture, then only the original domicile will be eclipsed. If not, original domicile will revive. But the domicile of origin prevails until a new domicile has been acquired. Yes, unless until the new domicile is acquired, then domicile of origin will be prevailed over there. So Indian decisions have broadly adapted. So we need not to go through the Indian cases here. Let us see that what.
Excuse me, Prof.
Yes, please continue. Please say.
There are two issues. Yes, I don't hear you very well. I am not sure if the problem is with me or with your network, but there are times we don't hear you at all.
See, in my recording,
That's one.
you could hear
Second,
everything clear. I repeat, in my recording, everything you could hear clear.
okay, another thing is our fellow Macmillan is waiting for you to join him.
So I want to admit him. Yes,
Yes, he's here already. Thank you.
I think I admitted already. Macmillan Lemma, yes, it is. I admitted. Thank you very much. So now, an independent person is allowed to give up his domicile of origin. Yes, he does have it. But the domicile of origin prevails until the domicile of has been acquired. Yes, it will prevail when unless until that you acquire the domicile. Then the domicile of origin will be eclipsed. Then let us go to the point of child. Let us see that the indentation in not worry. There is no reference in the judgment which did not relate to the conflict of laws situation at all, but as article. Thus, we need not worry about this article 5 of the Constitution of India, and we will only concentrate the principles involved over there is more important to us. The character of the domicile of origin is more tenacious, and it is hold stronger and less exactly shaken off. So domicile of origin is very much important factor, and that is very much we should consider. Domicile of origin which the law attributes to him adheres till the acquires another domicile. Yes, until unless a person gets another domicile, then only the original domicile will be eclipsed. The domicile of origin adheres to him ever if he has left the country with the intention of never returning to there till he has acquired the domicile of elsewhere by settling in that place with the requisite intention. Suppose if you left the country, like Tanzania, if you left it, and I went to the United States of America, and there you have the permanent intention to stay over there. At that instance, you carry the domicile of the United States, and the domicile of origin, that is the Tanzania, will be Poro. Both in England and concept and Indian concept, both are similar to each other. In case of England, the concept of domicile of origin is the creation of the common law. Of course, it is a common law rule would be there, where we can say that our domicile plays an important role. Next comes the domicile of origin has no necessary connection with the place where the child is born, and is theoretically possible for a person. Yes. Domicile of, yes, I repeat, domicile of origin has no necessary connection with the place where the child is born. Just I told you that your father and mother went to the United States of America where you were born over there. It doesn't mean that you are the domicile of that country. And it is theoretically possible for the persons has resided in such a country for any appreciable length of time. Even the length of time that you stayed over there, it doesn't matter that you will get the domicile of that country because accidentally you were born over there and you stayed for a longer. Unless until your father and mother acquires the domicile of the United States of America, at that instance, the Tanzanian domicile will be foregone. The domicile of origin continues to attach to each person till the obtains the different domicile called the domicile of choice. Yes, till the law attaches to the different domicile called the domicile of to him, and as when a woman, when her marriage was regarded at common law to have by such marriage acquired a domicile of her husband. Suppose a woman got married over there. At that time, what domicile she will acquire? Yes. Anyone can unmute and give me the answer? Did you understand the question? Shall I repeat the question? Are you with me? I did not get any reply from you, though your 3 members are present. Okay, there is some problem has occurred. That's why you could not hear me. Are you hearing me now? Participants, are you hearing me now? Please give me the answer.
Yes.
Yeah, there is a
Yes.
yeah, there was a little disturbance would be there, then I rectified it because here the internet, we cannot say when it comes and when it goes, one should have to be very much constant to touch with them, then unless until it will be there. So what I was discussing here is when a woman got married, then what her domicile would be? That is my question. Yes? Unmute and give me the reply.
Domicile of her husband.
The domicile of her husband automatically until the marriage subsistence. Okay, domicile of choice. Now let's see that. So domicile of choice.
I have a question.
Yes, please ask me.
How long does it take for someone to be declared to abandon his previous domicile?
It depends upon your conduct, permanent intention to stay over there. You have the bank balance and you enroll yourself as a voter and you will be the citizen of that country. If all these things should be give the sense that you acquire the domicile of that country and automatically the domicile of origin will be foregone. Is it clear?
Okay, yes, it is clear.
Yes. Now, let us see that domicile which any person can acquire. Not necessarily he is a rich and poor. Every individual person can acquire the domicile of choice by combination of number 1, actual residence in particular place, and number 2, intention to remain there permanently or for an indefinite period. While the domicile of origin is received by the operation of law at birth. The domicile of choice is acquired by the actual removal of the another country accompanied by this place of residence or settlement or permanent home. So in the choice, naturally, we will acquire it by following the permanent intention to stay over there, having the bank balance, having the citizenship, having the voter list, having the children to be admitted in the school, and paying the taxes over there, and being the member in a club, and being the member in any society. So that gives the sense that you are going to acquire the domicile of choice. The traditional statement that are no established domicile, there must be a present intention of the permanent residence, merely means that so far as the mind of a person at the relevant time was concerned, he possesses the requisite intention. So intention is very much important factor. Suppose if you stay in a particular place more than 30 years, but you don't have intention to stay over there, it doesn't mean that you acquire the domicile of choice over there, because you don't have such a intention to continue over there. The relevant time varies with the nature of the inquiry. It may be past and present. Several decisions of course, here again, when the Indian decisions, we need not worry about it. And domicile of choice is a combination of residence and intention. Of course, here the intention is more important factor. Residence, which is a physical fact, means bodily present at an inhabitant. Such a residence must be combined with the intention to reside permanently. At that instance, we can say that it is ultimate issue of this such a place. When a residence for the short period would suffice if it is coupled with the requisite intention. So now you can ask me, sir, can a person stays 30 years, 10 years, or he can stay for the 5 days also, but he can show the intention to stay over there. So here we want to say, for a short period would suffice, it is to be coupled with the requisite intention. If the requisite intention is there, the duration is not an important factor. Is it clear? Is it
Yes.
clear?
Yes, clear.
I appreciate
Yes.
it. Yes, I appreciate. Mere residence, even for the 10 years, are not enough. It cannot be established that the proposition held the requisite animus menendi, means a personally present over there for a longer time. The intention to live permanently for an indefinite period. So these are the two things will be coincide together to show that he is having the permanent intention to stay over there. When a person whose domicile of origin was British came to India as a missionary and lived in India for over 60 years with only short visit to Britain, it was held that he had acquired the domicile of the choice in India. Yes? Anyone?
I think
Yes?
is not.
Suppose if he has opened the bank balance, if you have the permanent intention to stay over there, and if you have the citizenship over there, and if you have the voter list over there, and is a member of the community, and is a member of the bank holders, and the students are admitted over there, or is the family is established over there, if such a thing would be there, then we can say yes, he is a domicile of choice in India. A person born in Goa, let us see that how example it is. A person born in Goa, I believe that Goa everybody knows in India. Sir, we don't know, only Tanzania we know, we don't know the other than Tanzania. Please have a big vision. If you born in a poor family, it is not your fault. If you die as a poor, it is your fault. Who said? Who said? Nelson Mandela. Microsoft owner. Who is Anyway, that let us see that. you can make it a corrections later on. So a person born in Goa whose domicile of origin was in Goa and who had established a business in Equity Housing and lived in Bombay for over 50 years with only occasional short visits to Goa had established a domicile of choice in Bombay. The requisite intention being established from this conduct. But I already told you, Goa and Bombay, it doesn't give the signify the domicile because Goa and Bombay both are both
In
are
India.
in India only. So domicile always represents the country. So domicile of origin was, of course, here again they given Sweden, where they acquired the Swedish nationality, then to Australia, but there was no evidence that they had intended to make Australia their permanent home after the domicile of origin continued and consequent relief would not be granted under the, of course, here they say the Hindu Marriage Act, whatever act may be there. What I want to say is here very much clear. If your intention to stay in a particular place permanently, then we can acquire the domicile of choice. For that instance, domicile origin automatically will extinguished. That's what I want to say here. Now let us see the domicile of independence. Who are the dependents? Can you tell me? Who are the dependents? Can you tell me? Sir, neighbors, friends, relatives. Who are the dependents?
One depending on someone else.
Suppose if I am a father and I do have my wife. My wife is a dependent and I do have the children and children are dependents. Is it clear? Suppose if I have the father and the father is a dependent. If I have the mother, then mother is a dependent. Jirani is the dependent? The neighbor?
No.
No, because there should be a consanguinity, blood relation. So, which means that the domicile of the dependent person is dependent on and usually changes with the domicile of someone else. Let us see. The object of determining the person domicile is to connect that person with some legal system of certain legal purposes. In general, a common law dependent, that is a married woman, minor, and a mentally deficient person were regarded as incapable of acquiring the domicile on their own, and their domicile followed by the person they were regarded as being dependent on it. Suppose a child would be there. The child is a dependent. As I told you that if the child is illegitimate, then the father. If the illegitimate, then the mother. Suppose the child is mentally retarded. Now you tell me. Yes? If the child is mentally retarded, then what is domicile? Parents, that is the father. I told you when it is illegitimate. If it is illegitimate, then automatically
Is the father. The father.
Legitimate mother, legitimate father. So the common law rules provided that wives are dependent of their husband. The wives are dependent of their husband. So if wife got married over there, then what her domicile? Yes?
Of her husband.
Of your husband. Why you are taking so much time to give the reply? automatically the husband, so long the relationship between the wife and the husband exists. Suppose if they are ceased to be the wife and husband, then automatically the wife will get the original domicile of her choice. So the father, in the case of the legitimate children born while he was alive, or the mother in the case of the both illegitimate children and legitimate children born after the death of the father. So I told you already that if it is illegitimate, who will be there? If it is illegitimate, who will be there? If the father is alive, and who will be there? And if the father is not alive, and what would be the domicile of a child? While they remain dependent person cannot be independently change the domicile of origin. If, on the other hand, the husband or the appropriate parent change her domicile, the domicile of the dependent usually changes with the domicile of such a person. Suppose the father domicile will be changed, then automatically the dependent domicile will be changed. And the father domicile is changed, then automatically the wife domicile also be changed as a change of his husband. So always dependent is an important factor, including the mentally retarded person. Domicile of a married woman. Yes, just before that we discussed. Yes, now you tell me, what is the position of a married woman? Yes?
She acquires the domicile of her husband.
She acquires the domicile of her husband. So the rule was considered absolute, admitting no exceptions, whatever the circumstances. Historically, it was based upon the ancient maxim of the common law that the husband and wife was one and the same person. They are the one entity, they say. They say they are the one entity. In the eye of law, the rule of the unity of the domicile of the husband and wife had been subject to vigorous criticism, both academic writers and judges. Of course, they do have their own way to make it out. In the case of the Putik versus AG, the petitioner, who is a petitioner, a German national with a German domicile of origin, was arrested in Germany and charged with the number of serious offenses there. Where he was charged with the serious offenses?
German.
German, I appreciate. That means you are with me and I am with you. So now he was arrested and charged with the number of serious offenses there. While on the bail, she absconded and using a illegal obtained passport from German national. So that petitioner is a woman. The petitioner is a woman. So she is such a sharp lady. What she did it? She got on a bail. She absconded and using an illegally obtained passport from German nationals. So he escaped from them and came to England and married an Englishman in 1975. The question before the court was whether she had acquired as an English domicile. Yes. Whether she has acquired the English domicile.
Yes.
Now let us see that it
She
was
did.
held that the rule of unity of domicile of husband and wife had been abolished by the domicile and matrimonial proceedings of 1973, and that therefore she did not acquire the domicile of England. Do you know that why she came from German to the England? Why she came from German to the England?
because she
In
was an intentional
1975?
child.
She's having the criminal charges there in German. And for the disguised form, and she got married to the Englishman, because when she got married to the Englishman, and she's thinking that she will get the husband's domicile. Is it not the indirect way of getting the domicile?
It is.
To abscond from the German? Is a disguised form of getting the domicile. So that is the reason they said it was held that rule of unity domicile of husband and wife had been abolished by the Domicile and Matrimonial Proceeding Act of 1973, and that therefore she did not acquire the domicile of England. The court further held that she did not and could not acquire the domicile of choice in England, as she was staying in England to avoid trial in the Germany. Is it clear?
Yes, Prof.
And not
Yes.
to set up a permanent home, the illegal entry and residence according to the court barred her from acquiring the English domicile of choice. Now she cannot acquire it. If you acquire it, is a disguised form of acquiring the domicile. So, yes, the court further held that she did not and could not acquire a domicile in England. The court further held that she did not and could not acquire the domicile of choice in England, as she was staying in England to avoid the trial in Germany and not to set up a permanent home. The illegal entry and residence according to the court barred her from acquiring the English domicile of choice. But India, they now completely outmoded the legal concept of the unity of domicile. Okay, this is a different aspect of it, how it can be, but general principles are the same, and where we cannot change it. The common law countries earlier followed the English common law rules. The rules that married woman has the domicile of their husband has, however, been abolished in Australia, Canada, Republic of Ireland, New Zealand, so that all these countries, a married woman is treated as having an independent domicile like any other person. So the people are doing mischief over there and coming to the another country and marrying it and getting the domicile of their husband. So that is the reason what the common law countries and English common law rules, they followed it. The rule married women had the domicile of their husband has, however, been abolished now in Australia, Canada, the Republic of Ireland, and the New Zealand, so that in all these countries, a married woman is treated as having an independent domicile like any other person. So here, the married woman giving the choice of the independent because of these reasons shown over there. Now let us see that domicile of legitimate children in India. As I already told you, legitimate children, father domicile, illegitimate children, mother domicile. At common law, could you read it? The domicile of legitimate child in India? Anyone can unmute and read? Is it visible?
It is.
Yes, please read 4.2.
Domicile of illegitimate children in India. At common law, where legitimating by subsequent marriage was effective, a legitimated child is to be treated as if it was legitimate. The rule of legitimating by subsequent marriage is unknown in Indian law. Though Muslims can acknowledge that an illegitimate child is legitimate. This can, however, be only done if it is uncertain whether the parties were married, and not if it is established that they were not.
Now the question is, Regarding the religion is concerned, Muslim law allows legitimation and Christian law allows adoption and Hindu law also allows adoption. When a child is adopted over there, then naturally the child domicile is the father of the child who adopted it, either in the Hindu law or in the Christian law. So that is the thing which I want to make it clear here. Domicile of illegitimate children, at common law, in other common law countries, and in any other, either India, in Tanzania or anywhere, the domicile of an illegitimate child was that of his mother, and which you made it very much clear. In Australia, the status of the illegitimacy no longer subsists in law. The domicile of an illegitimate child, called ex-nuptial child, is determined the same as that of the nuptial child. So the domicile of that father. Again, the question comes over there, whether child born in the tie of the wedlock, the child born out of the wedlock. In the tie of the wedlock, then we can say it's a legitimate child. Out of the wedlock, we can say illegitimate child. So that is the thing which I want to make it clear. Domicile of a mentally deficient person. So how it can be? Mentally deficient person. At common law, a person who is mentally retarded cannot acquire the domicile of choice because he doesn't know what he is doing and retains the domicile of he had before began to be legally treated as insane. Naturally, if it is in the custody of the father, then the father domicile will comes to him. If he is born mentally retarded or becoming a retarded when a child, he is to be treated as a dependent child. Now question comes, this is how the law in Australia and Canada will do. There is no Indian decisions or any other things would be there. But one thing I would like to make it very much clear is there. If it is a lunatic, if it is a mentally retarded, and what his domicile would be. Anyone? Anyone can unmute, give me the answer. And if you don't know, you say pass on, I will give you the answer. Yes? Oh, there is a problem. Yes, good. That's why you could not hear me.
Are you there, Prof?
Yeah. Now there is a, yes, now I am hearing you. Yes, please. Speak. Speak.
Could you repeat the question?
If a person is mentally retarded or deficient person, then what would be his domicile?
In the domicile he had before he began being mentally ill,
The answer is
or if
parents, father. He is illegitimate. He is the illegitimate mother. That is only the answer. Domicile of adopted child. As I told you just before, in the Hindu Adoption Act, in the Christian Adoption Act, in the Muslim Legitimate Act, if the adopted child automatically get the parents, those who adopted to him. Does the domicile of the minor child change to that of the adopting parent, or does it continue to be that of their natural parents? So now, natural parents will not be considered over there. Now, adopted parents will be considered over there. Did you get my point?
no,
Who are the natural parents? Who are the adopted parents? Yes? If you don't know, just pass on, I will give the answer.
Natural parents are those who are blood related.
The natural persons are those, parents are those who have begotten the child. And such natural persons will give the child to the adopted parents, then the domicile of the parent, the child becomes the domicile of yes. If you don't know, you say pass on, I will give the answer.
Pass.
Pass.
See, when the natural parents, those who begotten the child, they have given the child to the adopted parents. At that instance, the child domicile is adopted parents' domicile. Is it clear?
It is clear.
Yes.
Now, domicile of origin and domicile of choice contrasted. How it can be? Domicile of origin is fundamentally different from the domicile of choice. In other words, Cheshire is one of a good writer in the private international law. It differs in the character, in the condition necessary for its abandonment and the capacity to revival. The domicile of origin was, when compared with the domicile of choice, is much more enduring and the less easily shaken off, as already seen in the case like Venance versus AG displays a domicile of origin by a domicile of a choice. So now, domicile of choice is lost by removal of animo non reverendi. That means he doesn't want to be continue over there, and he wants to be make the other choice of law. At that instance, the domicile of choice, if he's getting over there, then the origin will be lost. If the choice would be still only staying over there, then he could not get it. The choice will not be domicile of choice. Here the test of intention is much less religious than the case of the displacing the domicile of origin. So now the question comes over there. Intention is a very much important factor to see that whether he wants to continue as stay permanently and for indefinite period, then we can say that at that time he acquired the domicile of choice and the domicile of origin will be eclipsed. And we have a beautiful case law, Ramsey versus Liverpool Infantry Limited, if I may not be mistaken properly. And I believe that, do you have an idea about that case law, anyone? Yes? If you know it, you tell me. If you don't know it, you say pass on. I will give you the answer. Don't waste the time.
Pass.
There is a Ramsey versus Liverpool Infantry Limited, if I'm not mistaken, the case law. This Ramsey actually belongs to the Scotland. Where is this Liverpool? Anyone? Where is
In
this
England.
Liverpool? It is in England.
England.
And this Ramsey, that fellow he doesn't earn anything. And he's a parasite. So he comes to the Liverpool because his sister is there, his brother-in-law is there, and his relatives are there, his mother is there, and so and so, one after another. Still they are lost over there, and he stayed in Liverpool only. But after some times he left a will, and the question comes, the will which is left over there at the time, which will be counted as a Ramsay's domicile, whether the Liverpool or Scotland. Yes.
At Scotland.
He never had an intention to stay in the Liverpool, but he's staying there only for the chakula, wooden shelter. Then naturally his Scotland, that is the choice of origin, will be continued over there, but not the Liverpool, even though he stayed there roughly 36 years, if I not be mistaken. So let us see, the domicile of choice is lost by the removal of, yes, that I already told, and we discussed this thing. Then the domicile of choice is acquired by the free will. Yes, I told you, no compulsion, no nothing. Likewise, it can be abandoned by the free will. Suppose if you want to abandon it by choice also, yes. Suppose if you abandon the domicile of choice, then what will be your domicile? Yes. Unmute
The
your
domicile
computers.
of origin.
The domicile of origin always will be with you till you die. So the domicile of origin, on the other hand, is imposed by the operation of law. In other words, domicile of origin is not a matter of free will and cannot be extinguished by the abandonment. It cannot be extinguished over there. If the domicile of choice is seized over there, then automatically the domicile of origin will come into the picture. The domicile of origin continues to be in operation until it is displaced by the domicile of choice. In the case of Bell versus Kennedy, it is one of the classical case law. You might have read it, like Woodney versus Udney. It is one of the classical case law where we can
Tanzania.